I'm here today to present House Bill 320. This deals with some changes in the current status of the employment law, in particular the Missouri Human Rights Act. The members, the returning members, let's see, we've got a freshman in here. The returning members are probably pretty familiar with this. To the freshmen, it's something probably a little bit new to you. And the fact of this is the same bill that we had last year. That's been filed again this year. I'll quickly hit the highlights on it. I don't want to dwell on it too long because of reiterating stuff that's been here multiple times. To begin with, we've got one of the main changes that starts this bill off is changing the standard of review as regards liability claims under the Missouri Human Rights Act. Right now, it's being applied in a contributing factor as being the standard. This bill changes it to give direction to the courts to be a motivating factor. The intention of this is to be able to give a standard where that the courts here in Missouri are able to consider more readily summary judgments. And right now, we're seeing where that a lot of those are not being taken up or they're being summarily overruled. This is to give this an earlier presentation to the courts so that it cuts down on the extended time of litigation and cost of litigation as well. And this standard would match what is currently being applied in federal employment law. We also have further clarification on the definition of what constitutes an employer. By adding in that it's a business that employs 6 or more employees for a period of 20 weeks for the calendar year before the occurrence. And that's rather than just the current definition says it's 6 employees. By doing that, we're making sure that an employer is actually someone who has a consistent record of employing at least 6 employees or more. We have in here that some exemption for private clubs that are tax exempt other than labor organizations. We also have the guarantee that a party to an action has a right to a jury trial and that the rules of evidence in Missouri apply. We've got in here that the court may award court costs, reasonable attorney's fees to the prevailing party if the judge determines the case is without merit. Damages and an award will include future lost wages or expenses, emotional pain and suffering, inconvenience, mental anguish, loss of enjoyment of life, and punitive damages. So those are to be included in the damages calculations, but at the same time, if it's a case without merit, the judge can give the prevailing party the court costs and reasonable attorney's fees for defending the case. We've got caps on damages. It's a graduated scale. Once again, we've done something that mirrors what's in the federal law, where that we go from the smallest employers, 6 to 150,000. You go on up to 100, 200, and ultimately an employer over 500 employees has caps on damages at 300,000. We also have an exemption for state and political subdivisions from exposure to punitive damages, and that is in everything except for fair housing claims. Last couple of years we've had some discussions and we've tried to put some language in here to clarify that fair housing claims would be exempt from this exemption. So writing things the way lawyers do, that's how it's in there. And then the last part of this, the language is the whistleblower section that we've presented before, dealing with whistleblower claims. Right now they are handled only in the case law, and what this will do is this will codify and bring the definition of what constitutes an employer, what damages they're entitled to, what the rights of the employer are on defending these claims within the statutes as being defined expressly, rather than it just being in the courts as we currently have it. With that brief overview, I'll yield the floor to any questions.
I represent the Missouri Chamber of Commerce in this endeavor. We've been coming back several years as a business community. Member relations with the Missouri Chamber of Commerce has been looking at this issue as one where we are competing against other states. Certainly, other states have standards which are more indicative of the Federal Civil Rights Act. And what we have been trying to do over the last few years is to homogenize the law, to make it the same, not only in the state of Missouri, but also the same with the Federal Civil Rights Act as well. So we're trying to make, with the MHO Act, one body of law. What we've seen over the years used to be that litigation was directed towards the federal courts. Over the past, I'd say 5 to 7 years, we have started to see more litigation trending towards the state of Missouri. Large part because of the standard which the Supreme Court has been using. And while it doesn't vary significantly, the difference in literally one word, in contributing versus motivating, has a significant impact in litigation. And when we see litigation coming across the state of Missouri in such a uniform fashion, where they're filing more in circuit court cases at the state level than they are at federal court, the reason behind it has to be because of the standard change. What's the standard change? The standard change comes down to this. In federal court, you have to prove motivating factor. That not only that it's out there, but they actually relied upon it. Some improper, illegal motive. In the state of Missouri, we have this contributing motivating factor. Well, contributing factor, what does that mean? It literally means that if there was one tiny piece of improper motive, even if it didn't rely upon it, that it is illegal. Now, there will be those who come up today and they'll testify about how that's great for Missouri. And, you know, they have their positions, and I'm not going to take away from them right now because they'll have that chance to do so. But in the state of Missouri, what we're seeing is companies are choosing to locate in other states. And I'm not going to tell you that this is the only reason. You know, this particular type of law is not the only reason that companies are doing it, but certainly it is a factor when companies look at the cost of their business in the state of Missouri. They have to have a higher litigation reserve. They have to have greater due diligence process when they hire folks. Their termination process are slow, in large part because of this. So there is an effect. Is it one that is the sole reason that a company doesn't come to the state of Missouri? No. There are many other factors to that. Taxes.
Right to work is the other one.
I am not here to testify on right to work today.
We spoke about that last week.
But there are factors, and this is one of those. The states surrounding the state of Missouri have chosen to use a standard more akin to the Federal Civil Rights Act, which you see embodied in this particular legislation before you today in House Bill 320. We have been going through this for years, right? Representative Elmer now 3 years out. This legislation in some form has been coming up for 6 years or more. We have been trying to reach a process, or reach a part of the process with the opposition who's been working against this, so that we can come up with some agreement. Now, for the last 2 years, we have passed some legislation that has got to be moved. I think it's incumbent upon us to find some compromise language so that we can put this issue to rest. I appreciate that the representative has taken up the fight again this year and hopes of finding that language that we can all agree upon. And it was my promise last year, and I continue it this year, that I'll work with anyone that we can come up with compromise language to make this legislation meet the governor's approval as well.